Hello, everyone, and welcome to Internet Law Review. For today's story, we have Stokeling versus United States from the United States Supreme Court. This is a case dealing with United States law known as the Armed Career Criminal Act. The Armed Career Criminal Act provides sentence enhancements for certain criminals who have been convicted of multiple crimes when those crimes involve certain violent crimes. And this law has been challenged and decided by the United States Supreme Court multiple times over recent years in deciding what qualifies as a violent crime. Because when you get into the details, you have to wonder exactly what that means. And this is exactly one of those kinds of cases. So we're going to read what this case is about and decide whether the U.S. Supreme Court thinks the crime in question is a violent crime that warrants this extra enhancement. So let's read on. Petitioner Stokeling pleaded guilty to possessing a firearm and ammunition after being convicted of a felony in violation of 18 U.S.C. 922. Based on Stokeling's prior criminal history, the probation office recommended the mandatory minimum 15-year prison term that the Armed Career Criminal Act provides for 922G violators who have 3 previous convictions for a violent felony. As relevant here, Stokeling objected that his prior Florida robbery conviction was not a violent felony, which the ACCA defines in relevant part as any crime punishable by imprisonment for a term exceeding 1 year that has as an element the use, attempted use, or threatened use of physical force against the person of another. The district court held that Stokeling's actions during the robbery did not justify an ACC sentence enhancement, but the 11th Circuit reversed. Held, ACCA's Elements Clause encompasses a robbery offense that requires the defendant to overcome the victim's resistance. As originally enacted, the Armed Career Criminal Act prescribed a sentence enhancement for certain individuals with 3 prior convictions for robbery or burglary, and defined robbery as the unlawful taking by force or violence, a clear reference to common law robbery, which requires a level of force or violence sufficient to overcome the resistance of a victim, however slight. So in common law, robbery is whenever you take property from a person by any amount of force whatsoever. So if you just take someone's property, that's larceny. If you take it from the person, that's considered a robbery. So a purse snatching, for example, would be considered a robbery, and that's normally the common law definition of robbery. So let's read on. When Congress amended ACCA 2 years later, it replaced the enumerated crimes with the Elements Clause, an expanded enumerated offenses clause, and the now defunct residual clause. The new Elements Clause extended the Armed Career Criminal Act to cover any offense that has as an element the use, attempted use, or threatened use of physical force. By replacing robbery with a clause that has force as its touchstone, Congress retained the same common law definition that undergirded the definition of robbery in the original Armed Career Criminal Act. This understanding is buttressed by the widely accepted definitions of robbery among the states, a significant majority of which define non-aggravated robbery as requiring a degree of force sufficient only to overcome a victim's resistance. Again, just a standard common law burglary or common law robbery, Common law robbery is any time you take property from a person. Burglary is when you take property from someone's home or other domicile, in case you wanted to know the difference between robbery and burglary. Under Stokeling's reading, many of those state robbery statutes would not qualify as the Armed Career Criminal Act predicates. But federal criminal statutes should not be constructed in ways that would render them inapplicable in many states. So what the United States Supreme Court here is saying that federal law is a federal law and therefore should be read in such a way as to apply to all the states unless Congress otherwise has clearly indicated. So when they're reading a term in the federal law, they're trying to read it in such a way as to universalize it if it can be done, and that's exactly what they're talking about here. The Supreme Court continues. This understanding of physical force comports with Johnson v. United States. The force necessary for misdemeanor battery addressed in Johnson does not require resistance or even physical aversion on the part of the victim. Rather, the slightest offensive touching would qualify. So battery is a common law tort and also a crime, and battery is simply when you, as it says here, provide any sort of offensive touching to another person. So assault at common law was a threat of force and battery was the actual force. These terms have become somewhat muddled in law today, and the terms assault and battery can be read either way. But at common law, there was this distinction where assault was clearly just the threat and battery was when there was actually the physical force. And that's what they're talking about here. Continuing on, the Supreme Court says, it is thus different in kind from the force necessary to overcome resistance by a victim, which is inherently violent in the sense contemplated by Johnson, and suggests a degree of power that would not be satisfied by the merest touching. So battery could be something as simple as, poking someone in the shoulder, even very slightly, if, or maybe like, shoulder checking someone or something like that would be technically a battery. But for a robbery against a person, you're looking for something that overcomes the resistance. So, shoulder bumping you would be not enough, but if the wallet was in your hand and I grabbed out of your hand, that would be enough because you're holding on to it and I overcame your resistance. So that would be the difference between a battery and robbery. Carrying on. Johnson did not purport, as Stokeling suggests, to establish a force threshold so high as to exclude even robbery from ACCA's scope. Stokeling's suggested definition of physical force reasonably expected to cause pain or injury, is inconsistent with the degree of force necessary to commit robbery at common law. And that's quite right by the U.S. Supreme Court. At common law, again, for robbery, you're looking for any amount of force, however slight, that overcomes the resistance of a person. So the purse on someone's shoulder, if you snatch it off it, that was resistant. The wallet in their hand, that would be resistance. So you're looking for some amount of force that overcomes the resistance of the person to overcome it. Moreover, the court declined to adopt this standard in Johnson. Stokeling's proposal would prove exceedingly difficult to apply, would impose yet another indeterminable line-drawing exercise in the lower court, as not supported by United States v. Castleman. Basically saying, look, you want us to replace one subjective line with another subjective line, at least as it relates to common law robbery. We have, since English common law to help us figure out exactly what that is. We have hundreds and hundreds of years to help us define what that is. And you want us to replace it with another line, which is a little bit less defined. And courts would have to go through this line drawing exercise. Well, why bother if we don't have to? Congress is using the common law term unless they are indicating otherwise, because it's a well-understood definition, so let's go with a well-understood definition. Seems right to me. The Supreme Court continues. Robbery under Florida law qualifies as an ACCA predicate of the offense under the Elements Clause. The term physical force in the Armed Career Criminal Act encompasses the degree of force necessary to commit common law robbery, any amount of force to overcome the resistance of the person. And the Florida Supreme Court has made clear the robbery statute requires resistance by the victim that is overcome by physical force of the offender. So the offender is the one who has to overcome the force for the robbery. Justice Thomas delivered the opinion of the court, in which Brio, Alito, Gorsuch, and Kavanaugh joined, and Sotomayor followed a dissenting opinion in which Roberts and Ginsburg and Kagan joined. So this is a 6-3 opinion in this case. So let's see a little bit about the dissent so we can understand why 3 members of the court felt otherwise. So we're going to read a little bit from the dissenting opinion. It says, in Johnson v. United States, the court ruled the words physical force in the Armed Career Criminal Act denoted a heightened degree of force rather than the minimal conduct that would have qualified as force for the purpose of common law crime of battery. Carrying on, the dissent states, as relevant here, Florida law defines robbery as the taking of money or other property from the person or custody of another when in the course of taking there is the use of force, violence, assault, or putting in fear. The Florida Supreme Court has interpreted the statute's reference to force to require force sufficient to overcome a victim's resistance, and said the degree of force is immaterial. The dissent continues, quoting from a prior decision of the court that was written by then Justice Scalia, in which Scalia wrote, we think it clear that in the context of a statutory definition of violent felony, the phrase physical force means violent force, that is, force capable of causing physical pain or injury to another person. Even by itself, the word violent constitutes a substantial degree of force. The dissent continues, in other words, in the context of a statute delineating violent felonies, the phrase physical force signifies a degree of force that is violent, substantial, and strong, force capable of causing physical pain or injury to another person. The dissent says the majority, slicing Johnson, concentrates heavily on the phrase capable of causing physical pain or injury and emphasizes the definition of the word capable to suggest that the precedent does not require any particular degree of likelihood or probability of pain or injury. Merely, as with a lost professor's eggshell victim hypothetical, potentiality. So the eggshell victim is a well understood concept in law that basically says you take a victim as you find them. So the idea is that if a normal amount of force would not hurt a normal person, if this particular person you are trying to attack, for example, has particularly brittle skin, brittle bones, or an eggshell skull, to use the term that's used at law, that if you hurt them, then you're responsible for it. Even though it wouldn't hurt another person, you take the victim as you find them. And so capable of would mean that would hurt the least person. So not this particular person, but presumably any person in Florida, which would include the elderly, which obviously is easier to injure them. The dissent in the opinion notes, as noted above, Florida's robbery requires force sufficient to overcome a victim's resistance, but that can mean easily no force at all. The government concedes similarly that a thief who grabs a bag from a victim's shoulder also commits Florida robbery, so long as the victim instinctively holds onto the bag strap for a moment. That would be true under common law. The dissent says that while these acts, of course, can be accomplished with more than minimal force, they need not be. And therefore, the Supreme Court dissents that Florida expands its law beyond the line that Johnson drew, in that the least capable conduct prescribed does not entail physical force, and since the least amount of conduct that would satisfy the statute does not qualify, we don't know exactly what amount of force he was convicted of because the court didn't need to reach that question, and therefore it would not qualify under the statutory text. So that is the case of Stokeling v. United States at the United States Supreme Court, and we can see a couple things by reading both the majority and the dissent. The first question is, when Congress passed its law dealing with physical force, did it mean to adopt whatever the state law definition is, or did it mean to adopt a national definition? And that seems to be a tension at the United States Supreme Court here. And the majority says it's a uniform definition, but you could obviously see where you could go the other way and say Congress was referring to whatever a state law would have, on the idea that if a state considers it to be serious enough to be a violent felony under its law, the United States would adopt that definition along for the ride, and vice versa. If it did not, then it would not adopt that definition along for the ride. Now, to the extent that that would be inconsistent for two prisoners who are being convicted of similar crimes, it would only be inconsistent to the degree that they were inconsistent in the underlying state crimes in the first place. So the exact same conduct in Florida or Pennsylvania or California could result in completely different charges or degrees of charges because states define their laws differently. And this applies to even things like murder. What might be murder in one state is not necessarily murder in another state because states adopt some idiosyncratic definitions, particularly along the margins. So you could conclude that Congress intended to adopt these idiosyncratic definitions, or you could conclude that Congress intended a universal definition. And the Supreme Court here says it's a universal definition, which is a reasonable conclusion, but I don't think one that is a foregone conclusion from the statutory text. As to the dissent, I agree with their reasoning, but I ultimately do not believe I agree with their conclusion. I agree with the dissent's opinion that the Florida statute, as is written, would encompass even the least amount of physical force that overcomes a victim's resistance, and I would agree that that is consistent with a common law definition of robbery, which again would necessitate even the least amount of resistance, but I don't agree with their conclusion that this would not qualify as a violent crime. In my view, even the least amount of touching would qualify as violent, even though it's not much violence. But then again, the United States Congress, when it wrote its terms, didn't define how much violence. Any amount of violence would do. So if it is a violent crime in so much as it overcomes your resistance, that seems to be what the United States Congress in its terms is contemplating. And so even under the dissent's view, where they say Florida law should apply, I would disagree with their conclusion that Florida law, under its least restrictive definition, would not be a violent crime because, as every first year law student notes by the United States Supreme Court's dissent, even the least amount of touching can be violent for the right person, and that's all that's required by the state's law. So I think even if you believe the United States Congress intended to adopt Florida's definition rather than universal definition, I don't think the dissent's conclusion follows. All things being considered, I tend to agree with the majority opinion. Whether or not this is a reasonable thing for Congress to do is, of course, a whole other matter. Whether or not they should define any amount of violence to qualify for a 15-year enhancement is, of course, a subjective call. But then again, this person would have been convicted of at least 3 crimes, one of which has a crime of violence. So you can take your pick as to whether or not that is a good policy or not for the United States Congress to have as it comes to a sentencing enhancement. But for now, my friends, that is all. I hope you're well. Until later, cheers and goodbye.